Welcome to Policy on Demand. I'm Pat Brown. The IRS last week issued a notice 2023-63, that many of us in the tax world have been anticipating. Section 174 guidance covering capitalization and amortization of specified research or experimental expenditures, and that is a mouthful. And the big question on the minds of taxpayers, what do I do on my 2022 tax return? Before we get started, I want to note that outside of this guidance, there are ongoing legislative efforts to retroactively reinstate R&D expensing, which of course was the law up until the 2022 tax year. It remains to be seen whether Congress will act on this issue, so taxpayers are looking to the Treasury Department for guidance if no legislative action is taken. With that, I'd like to welcome Cristy Turgeon, Dennis Tingey, and Adam Hales. Thank you all for being here. Well, we've got a lot to cover here, so why don't we jump right in. Adam, I'm going to start with you. I'd like you to give us a brief overview and address the intention of this notice and what are you hearing from companies. So we've got 45 pages, pretty dense material, not surprisingly, from the government in the form of a notice. What's in it and what are you hearing?
Yeah, thanks, Pat. Happy to. Notice 2023-63, it really provides directional guidance on a variety of Section 174 issues that are likely to be addressed in forthcoming regulations. From the notice, it appears that the IRS is open for suggestions, for comments on the rules as they've been outlined in the notice, even though the IRS has kind of directionally provided where they're likely to be headed. For example, the notice specifically requests comments on a variety of specific questions, including safe harbors, as well as some more general questions as well. I think this speaks to both the amount of issues that the notice covers, as well as the difficulty of the issues that the government is trying to address. And I think really indicates how willing the government is to hear from companies on these issues. As far as what I'm hearing from companies themselves, I think they're predominantly focused on understanding the immediate impact of the notice on their business. In this regard, the notice acknowledges the prospective nature of the guidance and expressly provides that any proposed regulations that will be issued, they will be effective for tax years ending after September 8th of 2023.
Got it. So Dennis, let me turn to you. Most calendar year taxpayers, of course, are right in the middle of filing, hopefully putting the finishing touches on their 2022 tax returns. What impact does the notice have on these returns?
Well, Pat, you and Adam, I think, hit the nail on the head, which is a lot of people, when this notice dropped, their primary concern is, have what I plan to do for my 2022 wrong? Do I need to change that? Do I need to address that? I think the IRS has done a really good job in the way that they've drafted this notice, which is, like Adam mentioned, the notice is not binding for 2022. It's really to provide directional guidance to taxpayers as to what the IRS is thinking. And you see that in a number of different places in the notice. So, for example, the IRS lets people know what the effective date of any proposed regs would be, which would be for tax years ending after the date the notice was issued, which exempts 2022 tax years. The IRS also acknowledges, when they talk about the procedural guidance that may be coming, that there'll be a recognition that some taxpayers may not have prepared their 2022 returns consistent with the notice. And so I think big picture wise, the IRS is trying to provide taxpayers some guidance here on these very difficult issues. It's requesting comments, but also acknowledging that for 2022, we're pretty late in the game. And so I think for taxpayers, this really means a couple of things. If you're a taxpayer who has already locked down your 2022 approach, I think you can look at the notice for some directional guidance, but feel comfortable maintaining the reasonable positions that you've already taken. I think for taxpayers who still have some flexibility, they may want to look at the directional guidance in the notice and maybe look to adjust some of the computations or the approaches that they've taken so far in preparing to do their 2022 returns. But big picture is, I think that taxpayers don't need to feel bound by the notice, but I do think it provides some really good directional guidance to taxpayers.
So Dennis, that's a really important point, just to reiterate for our viewers. With respect to the 2022 year and returns that are just about done, the option to look at this guidance and apply it, but also to the extent you've already established reasonable positions, maybe maintain those positions, at least with respect to your 2022 tax return. I think that's a really key point. Adam, let me come back to you. So an area with a lot of questions related to the question of the definition of software development. And the IRS and Treasury spilled some ink on this issue as well. So how did the notice approach this?
As you indicate, this is another area where I think the tax community was really looking for guiding principles, if you will, since software development is such a prevalent item in today's world. And lots of questions exist as to whether something is software development or simply, maybe maintenance relating to existing software. So in this regard, the notice really focuses on the terms computer software, and they borrow heavily from the definition that already exists in Rev Proc 2000-50. The notice also focuses on some new terminology that we haven't seen before, called upgrades and enhancements, and they really focus on those upgrades and enhancements that modify existing computer software and result in really additional functionality as the type of cost that would be subject to 174. The notice provides, I call it a non-exhaustive list of different activities that would be treated as software development, as well as a list of activities that would not be treated as software development. And I think notwithstanding these examples or these lists, I think it's likely going to remain really difficult to distinguish between what is a software upgrade or enhancement, which would be subject to 174, and what is, kind of software maintenance activities, which wouldn't be subject to 174 according to the notice. And to me, I think this is really an area where additional comments from companies may be extremely helpful.
So that's a key point, and one that we should make sure our viewers are aware of as well. Obviously, as with a lot of probably all Treasury IRS notices, there is an invitation for the taxpayer community to comment on this. And obviously, as you noted, software development, one of the issues that people may want to comment on. So Cristy, one of the things we already mentioned is the possibility that Congress does act in this area and reinstates former Section 174, allowing for the current deduction of these expenses. Does the notice contemplate that in any way?
It could be that they are contemplating potential retroactive repeal, in particular because they make clear that these rules will have no implication on costs incurred prior to 2022. So under prior law, which kind of goes back to status quo. We've also heard that if they do change and likely would allow taxpayers to implement method changes prospectively or to amend returns if they wanted to go back to the old rules. So there's discussions about how you're going to implement that if, in fact, the government does retroactively reinstate 174. So yes, it definitely has been in discussions, and I suspect that they were contemplating that.
Dennis, back to you. Another area of certainly a significant interest to taxpayers, contract research arrangements. A lot of questions on contract research arrangements and the scope of the kinds of R&E costs that potentially are impacted here. How does the notice address this?
Pat, this has been one of the very, very hot topics of discussion among taxpayers as to when you look at the historical approach to 174, this didn't become an issue because everyone could expense if you wanted to. Now that you have mandatory capitalization, how companies are going to address contract research arrangements has really been an interesting topic to decide, could there be a situation where there's what we would sometimes refer to as double capitalization or triple capitalization for the same type of research activity? The notice, I think, puts at rest one of the concerns or one of the potential ways that the government could have addressed this, which is to say any research activity has to be capitalized under 174, even in a contract research arrangement, which would have allowed for two parties to capitalize for the same activity. Instead, what the government did, which is consistent with some of the comments they've made historically and in other sort of public forums, is to generally say a pure activity-based test isn't what the direction they're heading with the guidance. But they do have concerns when a contract researcher might have some financial risk or might have some rights to the end research. And so the way that the rules are outlined in the notice is to basically say in a pure contract research arrangement where the contracting research party doesn't have any rights to ownership, doesn't have any financial risk, almost like a cost plus type of arrangement, only the party that is paying for and receiving the benefits of the research would have to capitalize under 174. However, the notice also acknowledges that if the contract researcher as an element of financial risk, or they have an element of ownership or rights to the illegal rights to use the IP that's created out of the research, right, then they may be subject to 174, and under the notice would be subject to 174. I think, like Adam said earlier, this is going to be an area where taxpayers can comment on, try to provide the government some insight as to how these arrangements work. I think there's a need for a materiality threshold perhaps to be adopted here on some of these interests. And it's clear that the IRS is borrowing from other sort of ownership principles and past guidance in adopting the financial risk and the ownership test. And yet at the same time, it does have the potential for very similar taxpayers to maybe be treated differently. So this is one area that I think a lot of people have been looking for. I think the big picture is that the IRS in the notice seems to be moving away from a pure activity-based test, but exactly how the contract research rule will be finalized in the regulations, I think they're very open to comments, and I think taxpayers should feel the need to comment and to help the IRS on this difficult question.
Yeah, so Dennis, that's a really important point. Thanks for raising that. So this whole concept of element of financial risk, essentially, as you suggest, easy to say the words, may not be as easy to figure out exactly what that means in practice. And there are obviously, a plethora of arrangements that taxpayers may have with respect to other parties, and figuring out what represents an element of financial risk seems like an area that's ripe for comment. I couldn't agree more. So Cristy, let me come back to you. Another area with lots of questions was the capitalization of indirect costs. What did the notice tell us about this issue?
You are right. There's been a lot of speculation as to what it means to be incurred in connection with the specified research activities, which is the standard that's established in the statute. And based on guidance applicable to former 174, it seems clear that some amount of indirect costs likely would need to be capitalized, but it is unclear whether the IRS would take a direct overhead approach, like previous case law and rulings perhaps applied, or they would take a broader approach that would pull in all the G&A costs like UNICAP or 263 Cap A, or maybe an elective approach like a 263 little a type approach. In the notice, the IRS took the approach that seems consistent with former 174 in requiring capitalization of direct occupancy overhead costs only. And significantly, the IRS indicated that other costs, such as G&A and interest, are not required or permitted to be capitalized to your SRE, to your specified research expenditures. And they also provided for a consistency in characterization of your expenditures for all purposes, including, for example, 162, 195, 263 A, 263 Cap A, 471, 861, et cetera. Lots of code sections, but basically for all purposes requiring consistency.
Dennis, I want to come back to you. In the business world, change is a constant. IP moves, businesses get restructured, IP gets sold. What does the notice tell us about situations involving Section 174 costs when businesses are sold or restructured? Does the notice tell us anything about these situations?
This is one of the really fascinating areas about the changes that were made to 174, is there was a new addition to 174 added when the statute was changed that basically Congress denoted that if you had a disposition of a 174 type of activity or asset, that you would not be permitted to recognize a deduction for that. And taxpayers have been wrestling with exactly what that was intended and to mean and how it would be applied in practice. Conceptually, historically, before the statute was changed, I think most practitioners, as well as the case law and even the IRS in the background of the notice acknowledges that normally you would think of research and experimentation costs as being capitalized because they are help developing the related IP that's associated with the research. And as such would almost attach to the IP type asset. The language that's found in the new statute raises a question as to whether or not the R&D expenditures are sort of detached from the underlying property to which they help create. I think the notice illustrates that in the direction of the IRS, they are going with the sort of approach that the cost of 174 that get capitalized are detached from the IP. And as a result, when you dispose of the IP in sort of a normal restructuring type transaction, or even in just a sell or exchange, that basis would stay behind. and continue to be amortized. There's some exceptions to that rule when taxpayers go out of existence. The notice provides sort of a blanket recognition that none of the rules are applicable in a partnership setting. They're still working on those kind of rules and principles. But I think this is another place where lots of sort of residual consequences to the idea of separating the basis from the IP conceptually. And the IRS has asked for help and guidance on this. I think companies would be wise to comment on that. And like you said, Pat, this is one of the things that companies regularly undergo in sort of restructuring and moving things around. And now this new sort of direction that the IRS is headed with this is going to have some real big consequences that taxpayers need to think about when they're engaging those sort of IP and restructuring transactions.
Thanks, Dennis. So I'm now going to ask a dangerous question to Cristy, which is what else? Any other big issues that we haven't talked about already that are addressed in the notice?
There definitely are a lot of other significant issues. In particular, the notice addressed areas that were raised by commentators where the change in treatment of 174 expenditures to require capitalization rather than allow a current deduction resulted in potentially unintended results. And for example, the notice addressed the treatment of specified research that are applicable to long-term contracts under Section 460, where currently the rules appear to require the cost incurred to be included in your percentage of completion calculation, as opposed to the costs that are taken into account in computing taxable income. And the notice proposes to change the numerator of that percentage of completion calculation to include only the amortization of the 174 expenditures, and have requested comments with respect to the denominator. So hopefully providing some relief in that regard. The notice also addressed the treatment of specified research and cost-sharing arrangements under Section 482, where the current rules could be read to require taxpayers to recognize income if the cost-sharing payments exceed your current year deduction. And the notice proposes to reduce the cost incurred that are capitalized as well as deducted by those cost-sharing payments, which hopefully will resolve that potentially unintended result. And the notice significantly did not address some other unintended consequences that have been raised by practitioners, including Section 280C, which is the rules with respect to the reduction in basis to the extent that you are taking an R&D credit. And currently those rules appear to require your basis to be reduced only to the extent your credit exceeds your current year deduction, and possibly because that type of correction may need a legislative fix as opposed to a regulatory fix. But that 280C kind of guidance was not included in this notice. I think taxpayers may have been expecting it to be included.
One final question to you. So what's next? What's next for the government and what's next for taxpayers?
So comments are due November 24th. So impacted taxpayers should definitely consider commenting because the government doesn't know what they don't know. And if no one complains or comments, they'll think the rules are perfect and issue them as proposed. And so in my view, and based on some of the things that we've discussed in this policy on demand, there are definitely room for improvement with respect to like contract research and dispositions, for example. So definitely worth commenting. And given that the comments aren't due until the end of November, I think it's highly unlikely that the government would have temporary or final regs by December 31st of 2023. So it's likely that the earliest effective date of final rules would be 2024. So as noted by my colleagues, until those final regs are issued, taxpayers can choose to rely on a reasonable interpretation of the statute or to rely on the notice if they were to rely on it in full. But definitely, it's unlikely that we will have final rules that we have to comply with until 2024.
Got it. So a little bit of time to get comments in, but as we've just been discussing, each of you guys have been discussing an awful lot potentially to comment on.
Or for the government, for Congress to change the statute.
And that as well, right, exactly. Okay, so we're going to leave it there. Cristy, Adam, Dennis, I want to thank you all for sharing your insight today.
Thank you.
Thanks.
Thank you.
So there's a lot more to come, not just with Section 174, but also the CAMT guidance, which was released Tuesday. Stay tuned to Policy on Demand for a conversation about that notice. In the meantime, to our viewers, we appreciate you spending this time with us. Take care.